Legal Ethics. Reported by CAROLA, Jhelleni and M. Rule 71 of the Rules of Court. Contempt, direct and indirect contempt. Contempt of court. It is exercised on preservative, and not on vindictive principle and on corrective, rather than the retaliatory idea of punishment, for purposes that are impersonal. It is criminal in nature. The power to punish for contempt is inherent in all courts. It is essential in the observance of order in judicial proceedings and to enforcement of judgment, orders and writs. Kinds of contempt. Direct contempt consists of misbehavior in the presence of or so near a court or judge as to interrupt or obstruct the proceedings before the court, or the administration of justice. Indirect or constructive contempt. It is one committed away from the court, involving disobedience of or resistance to a lawful writ, process, order, judgment or command of the court, or tending to belittle, degrade, obstruct, interrupt or embarrass the court. Civil contempt. It is failure to do something ordered by the court, which is for the benefit of a party. Criminal contempt consists of any conduct directed against the authority or dignity of the court. Acts of a lawyer constituting contempt. Misbehavior as officer of court. Disobedience or resistance to court order. Abuse or interference with judicial proceedings. Obstruction in administration of justice. Misleading courts, making false allegation, criticisms, insults, veiled threats against the court. Aiding in unauthorized practice of law whether suspended or disbarred. Unlawful retention of client's funds. Advise client to commit contemptuous acts. Rule 71 of the Rules of Court. Contempt. Section 1. Direct contempt punished summarily. A person guilty of misbehavior in the presence of or so near a court as to obstruct or interrupt the proceedings before the same, including disrespect toward the court, offensive personalities toward others, or refusal to be sworn or to answer as a witness, or to subscribe an affidavit or deposition, when lawfully required to do so, may be summarily adjudged in contempt by such court and punished by a fine, not exceeding 2,000 pesos, or imprisonment not exceeding 10 days, or both, if it be a regional trial, court or a court of equivalent or higher rank, or by a fine, not exceeding 200 pesos or imprisonment, and not exceeding 1 day, or both, if it be a lower court. Section 2. Remedy therefrom. The person adjudged in direct contempt by any court may not appeal therefrom, but may avail himself of the remedies of certiorari or prohibition. The execution of the judgment shall be suspended pending resolution of such petition, provided such person files a bond fixed by the court, which rendered the judgment, and condition that he will abide by and perform the judgment should the petition be decided against him. Section 3. Indirect contempt to be punished after charge and hearing. After a charge in writing has been filed, and an opportunity given to the respondent to comment thereon within such period as may be fixed by the court and to be heard by himself or counsel, a person guilty of any of the following acts may be punished for indirect contempt: misbehavior as officer of court, disobedience or resistance to court order, abuse or interference with judicial proceedings, obstruction in administration of justice, assuming to be an attorney or an officer of a court, failure to obey a subpoena duly served, the rescue, or attempted rescue, of a person or property, in the custody of an officer, by virtue of an order, or process of a court held by him. Section 4. How proceedings commenced. Proceedings for indirect contempt may be initiated motu proprio by the court, against which the contempt was committed by an order, or any other formal charge requiring the respondent to show cause, why he should not be punished for contempt. Section 5. Where charge to be filed. Where the charge for indirect contempt has been committed against a regional, trial court or a court of equivalent or higher rank, or against an officer appointed by it, the charge may be filed with such court. Where such contempt has been committed against a lower court, the charge may be filed with the regional trial court of the place in which the lower court is sitting, but the proceedings may also be instituted in such lower court subject to appeal to the regional trial court of such place in the same manner as provided in Section 11 of this rule. Section 6. Hearing, release on bail. If the hearing is not ordered to be had forthwith, the respondent may be released from custody upon filing a bond, in an amount fixed by the court, for his appearance at the hearing of the charge. On the day set therefor, the court shall proceed to investigate the charge and consider such comment, testimony or defense as the respondent may make or offer. Section 7. Punishment for indirect contempt. If the respondent is adjudged guilty of indirect contempt committed against a regional, trial court or a court of equivalent or higher rank, he may be punished by a fine, not exceeding 30,000 pesos, or imprisonment not exceeding 6 months, or both. If he is adjudged guilty of contempt committed against a lower court, he may be punished by a fine, not exceeding 5,000 pesos or imprisonment, not exceeding 1 month, or both. If the contempt consists in the violation of a writ of injunction, temporary restraining order or status quo order, he may also be ordered to make complete restitution to the party injured, by such violation of the property involved or such amount as may be alleged, and proved. The writ of execution, as in ordinary civil actions, shall issue for the enforcement of a judgment, imposing a fine, unless the court otherwise provides. Section 8. Imprisonment until order obeyed. When the contempt consists in the refusal or omission to do an act which is yet in the power of the respondent to perform, he may be imprisoned by order of the court concerned until he performs it. Section 9. Proceeding when party released on bail fails to answer. When a respondent released on bail fails to appear on the day fixed for the hearing, the court may issue another order of arrest, or may order the bond for his appearance to be forfeited and confiscated, or both, and, if the bond be proceeded against, the measure of damages shall be the extent of the loss or injury sustained by the aggrieved party by reason of the misconduct for which the contempt charge was prosecuted, with the costs of the proceedings, and such recovery shall be for the benefit of the party injured. If there is no aggrieved party, the bond shall be liable and disposed of as in criminal cases. Section 10. Court may release respondent. The court which issued the order imprisoning a person for contempt may discharge him from imprisonment, when it appears that public interest will not be prejudiced by his release. Section 11. Review of judgment or final order, bond for stay. The judgment or final order of a court in a case of indirect contempt may be appealed to the proper court as in criminal cases. But execution of the judgment or final order shall not be suspended until a bond is filed by the person adjudged in contempt in an amount fixed by the court from which the appeal is taken, condition that if the appeal be decided against him, he will abide by and perform the judgment or final order. Section 12. Contempt against quasi-judicial entities. Unless otherwise provided by law, this rule shall apply to contempt committed against persons, entities, bodies or agencies exercising quasi-judicial functions, or shall have suppleatory effect to such rules as they may have adopted pursuant to authority granted to them, by law to punish for contempt. The regional trial court of the place wherein the contempt has been committed shall have jurisdiction over such charges as may be filed therefor. Philippine jurisprudence. Zaldivar vs. Gonzales. Zaldivar was the governor of Antique. He was charged before the Sandiganbayan for violations of the Anti-Graft and Corrupt Practices Act. Gonzales was then tinawag by an ombudsman who was investigating the case. Zaldivar then filed with the Supreme Court a petition for certiorari, prohibition and mandamus assailing the authority of the Tanad-Bayan Ombudsman to investigate graft cases under the 1987 Constitution. The Supreme Court, acting on the petition, issued a cease and desist order against Gonzalez, directing him to temporarily restrain from investigating and filing informations against Zaldivar. Gonzalez, however, proceeded with the investigation and he filed criminal informations against Zaldivar. Gonzalez even had a newspaper interview, where he proudly claims that he scored 1 on the Supreme Court, that the Supreme Court's issuance of the TRO is a manifestation that the rich and influential persons get favorable actions from the Supreme Court, while it is difficult for an ordinary litigant to get his petition to be given due course. Zaldivar then filed a motion for contempt against Gonzalez. The Supreme Court then ordered Gonzalez to explain his side. Gonzalez stated that the statements in the newspapers were true, that he was only exercising his freedom of speech, that he is entitled to criticize the rulings of the court, to point out where he feels the court may have lapsed into error. He also said, even attaching notes, that not less than 6 justices of the Supreme Court have approached him to ask him to go slow on Zaldivar and to not embarrass the Supreme Court issue. Whether or not Gonzalez is guilty of contempt. Ruling. Yes. The statements made by Respondent Gonzalez clearly constitute contempt and call for the exercise of the disciplinary authority of the Supreme Court. His statements necessarily imply that the justices of the Supreme Court betrayed their oath of office. Such statements constitute the grossest kind of disrespect for the Supreme Court. Such statements very clearly debase and degrade the Supreme Court and, through the court, the entire system of administration of justice in the country. Gonzalez is entitled to the constitutional guarantee of free speech. What Gonzalez seems unaware of is that freedom of speech and of expression, like all constitutional freedoms, is not absolute, and that freedom of expression needs on occasion to be adjusted to and accommodated with the requirements of equally important public interests. One of these fundamental public interests is the maintenance of the integrity and orderly functioning of the administration of justice. There is no antinomy between free expression and the integrity of the system of administering justice. Gonzalez, apart from being a lawyer and an officer of the court, is also a special prosecutor who owes duties of fidelity and respect to the Republic and to the Supreme Court as the embodiment and the repository of the judicial power in the government of the Republic. The responsibility of Gonzalez to uphold the dignity and authority of the Supreme Court and not to promote distrust in the administration of justice is heavier than that of a private practicing lawyer. Gonzalez is also entitled to criticize the rulings of the court, but his criticisms must be bona fide. In the case at bar, his statements, particularly the one where he alleged that members of the Supreme Court approached him, are of no relation to the Zaldivar case. The Supreme Court suspended Gonzalez indefinitely from the practice of law. Thank you very much and God bless.